Hello, my name is Professor Brett Davies. Today we're going to build simple single will on our law firm's website. So you can build wills. So I'm going to estate planning and here I am. There's the 4 wills here. I can build a mutual will, which is all to mum, all to dad. And I can build mutual simple wills, all to dad, all to mum, without any tax planning. And I can build a single will. That's for a person which the spouse has died or never got married or have no life partner with 3 generation testamentary trust wills. But today I'm going to be building a single will, which is a simple will with no tax planning. If you've got $1 million or more, or you're want to make sure that you're protecting reducing the tax of your estate, consider building a 3-generational testamentary trust will, a single one. But in this instance, we're going to build a simple single will. Perhaps it's a young person that hasn't got many assets. Now, this is interesting. I can see a sample of the document, but I'd like to see a sample of the document. It's very generous of Legal Consolidated to have that. This is on all our documents we sell, the hundreds and hundreds of documents we sell, you always get a sample document to look at. And while you could answer the questions differently, and the sample in your document might look a bit different, this will be similar to the document that you will build. So this is a simple single will. There's a revocation of previous wills. There's the executors. I've got 3 executors there. They made the age of majority 18 years of age. It's pretty common. And they've got 1, 2, 3, 4 residuary beneficiaries. Someone's getting 25%, 25%, 25%. And this Ronald is getting the assets at 99 years of age. He's probably either a spendthrift or suffering a mental disability, in which case the executors will hold the money in trust and drip feed it to him. That could also help with Centrelink and government help as well. Looking good. Minors and bankrupts, protective trusts, nice. The trustee's powers. There's some. She's potentially contemplating a marriage, contemplating a divorce. She's contemplating everything. This person. And there's a signing clause, signing in blue ink. Wonderful. And there's the covering letter. All documents you sell, you'll get a letter on our law firm's letterhead. We're a national law firm, setting out how to sign the wills and other matters as well. Well, that's good. I'm happy with that. I would like now, I'm quite excited, I'm going to start building the will now. Now, I am going to start answering the questions, and as I go along, there'll be plenty of hints. Now, if you're not a member, and membership's free, just put in your username and password, that will make you a member, and I've just put that in, and now I'm going to start my single will. But before I do, I might have done a power of attorney for these clients, for this person, in which case I'll just pick up I'll just pick up the information I've used before, and it will populate the single will, and save me having to type all the data, all the information again. But in this instance, I'm just going to start a brand new single will. Well, there's a set of questions that are being asked, and there's hints all the way through. So, to the tax man I leave. So this will be an article to say that you should, if you want, build 3-generational testamentary trusts. There's the reasons for it, and there's a training video on that as well. So you can always watch plenty of training videos. But in this instance, I'm happy to build a single will without any tax planning. So I'm going to put my client's details in. We now have our client's name, Mary Popular, and she was born in 1999, and she lives in Paddington. We're a national law firm, so these wills work in all jurisdictions, including Tasmania, which has the highest complexity of signing. Well, I'm happy with that. I'm going to press next. Now, if there's a green tick, it means that our logic flow has been satisfied, and we're happy with that. Now, Mary Popular may have had assets in another name, in which case she'd put her details in there. It might be an unmarried name, that could be her second name or third name. But in this instance, Mary only has assets in that one name, so she's happy to leave that as no. Now, the executors carry out your wishes in your will. If you have children, and you're leaving everything to your children, they're the best executors. If the children are 6 months old and 5 years old, they're still the best executors because they'll probably be in their 60s when you die. So I would always appoint your children the executors if you're leaving everything to them. In the unlikely event the children are under 18 years of age, then you just appoint an Uncle Harry, and we're going to do that today. So Mary has 2 children, and one's under 18 years of age, so she's going to appoint Uncle Harry. So we're going to put the 3 executors in. So here's Mary's first child, and you're best to put the children in by age, so the oldest goes first, and it's Brett Davies. And because Brett is over 18 years of age, or the age majority that's required, that's going to be left blank, and Brett lives in Footscray. So I'm not pressing next, I'm going to press add another backup executor. I'm going to put the second child in as the executor. That's Mary. Smith. Now Mary is actually under 18 years of age, but I'm going to leave it blank nonetheless because it defaults to the youngest age of 18, and I'm happy, the client's happy for Mary to have that address as well. Now, because Mary is under 18 years of age, I'm not really comfortable in just having young Brett as the executor alone. So I'm going to put in an auntie that I trust, my children's auntie that I trust, and she will be the 3rd executor. Now, if my children are all over 18 the day I die, then that's fine. Angelina can just merely renounce, so she doesn't have to do that. And she's in Perth, Western Australia, and that is completely fine to have people in other states doing the job. So I've now got my 3 executors. I've got the children, one of which is very young, and because of that I've added a 3rd executor. Now the next question is age of majority, and that's the age which you will allow your beneficiaries, in this case the young lady's children, this will allow her to change that. Now in this instance she is happy for the age of majority to be 18 years of age, and that's common for most people, but now my father says you don't reach maturity to your man until you're 50 years of age, and now I'm 50, he thinks it's a bit older. So it's really up to you. You can make that 21, 25. There's substantial maintenance clauses put in all our wills at Legal Consolidated, so you can make it older than 18. In this case, I'm going to leave it at 18. Lots of hints for you to look at. If the child is disabled, for example, then you would probably dial up the age majority to 99 years of age, and the executors would have control to drip feed the child, the disabled child, the wealth as that child needs it. In this instance, the client has just got 2 kids, age majority is going to leave it 18. Now the next question is specific gifts. I hate them, I think they're a disaster. Now I know you have Ludrow, I know you've got a beautiful car, I know that you want the boy to get the tools in the garage, the daughter to get jewellery. Forget about all of that. It just adds huge complexity to your will. You can do it, it's there, look, it's there. You can press yes and put it in there. But it's just a disaster because you have 3 problems. You don't know when you're going to die, you don't know what assets you'll own, you don't know what the tax laws will be, and therefore it's best to say no to specific gifts. The children will work out who gets the jewellery and who gets the stuff in the garage. I wouldn't worry. In this case, the client's going to press no. Now the residuary beneficiaries, that's who gets anything that's left. So if there's no specific gifts, it's basically everything. And in this instance, she is going to do what most parents do. She's going to leave everything to her 2 children equally. So let's put that in. So the first child is Brett Davies, and the percentage will be, we could make it 50%, or we could make it a half. So in this instance, I'll make it a half. If it's a third, it will then go in as a third. if you had 3 children. Whatever you do, don't put in, and the hints will show this too, don't put in 33.3% because times that by 3 does not bring you to 100%. So I'm going to put a half in this instance. And the age, the client's not fussed with it, it's just going to default to 18, so I'm going to leave that blank. And we're now going to press add the second child, add a residuary beneficiary. I'll put the girl's name in. Now she's underage, but she's still getting half of everything, but only once she turns 18 by law. So the client has two children, Brett and young Mary, and they are getting everything equally, so there's half to there and half to the boy. No age of majority because it defaults to 18 and the client's happy with that. So now we're going to press next. We are now going to look at a disaster clause. This happens to be an important clause to press yes to if you travel with your children, in which case you might want to leave everything to your brother and sisters or your parents. So in this instance, the disaster clause is when you're dead, your children are dead, both children are dead and never had children. So the bloodline of that client is now wiped out. In that case, you'd press yes. You wouldn't press yes if the children were not travelling with you. So this is very unlikely that will die. So in this case, the oldest boy no longer travels with the family. He's doing his own thing with his own girlfriends and what have you. So the disaster clause is not required in this will because one of the children is no longer travelling with mum. The family are not all travelling together. So we're going straight to guardianship clause. Now, a guardianship clause is really important if you have children under 16 years of age, but even if you have children under 18, I would still put it in. Now, in this instance, the youngest daughter is 18, and we're going to have the guardian being her older brother. So we're going to put him in, because if mum dies, then it would be appropriate for the boy, who's still living at home, to look after his sister at home. You might have a different view. You might well decide to have an uncle perform that job. Or maybe you have the uncle and the oldest child do it. Or maybe the oldest child is under 18, in which case you'd have an uncle and aunt do that. In this instance, Brett is over 18 and he can do the job looking after his sister. We don't need it much longer because the daughter will be of age very soon, and the children are generally 60 years of age when you die. Now, consider person clause. You can put in your will if someone's going to challenge your will. Who can challenge your will? Read the hints and find out. But it's basically your parents, people you sleep with, like a husband, wife, your children and your grandchildren. In this instance, the lady's leaving everything to her 2 children. She's no longer has a life partner, and therefore it's fitting to leave it to the 2 children. It will be very difficult to challenge. But if she thought someone was going to challenge it, like an ex-husband that's still receiving maintenance, then she might well complete and put her ex-husbands there. But if the husband's done a property settlement and she's not paying him maintenance, he can't challenge generally under most jurisdictions. Now, contemplation of marriage. If this lady has a beau, she has someone that she might want to marry in the future, then if she does marry that person, if Mary does marry that person, then this will's revoked. Well, that's not much good. So what Mary's going to do is she's going to say, yes, I might get married to this certain person. You have to know who he is. Let's call him Fred. Fred Jones. But if she doesn't marry Fred Jones, the will remains valid. If she does marry Fred Jones, the will remains valid. So she's very cautious. She'll put the name of Fred Jones in there. Now, it might have been the case that Mary has not yet divorced her old husband. In which case, if they do divorce, it might be 20 years since she's seen her old husband, and they haven't bothered to get a divorce, but if they do now get a divorce, this will becomes invalid unless the name goes in there. But thankfully, Mary's husband divorced many years ago, so we don't have to worry about that. Now we go to the reference. Majority of our wills are drafted by lawyers, financial advisors and accountants, and they'll want to put in their reference number. If they've done 400 or 500 wills, they might want to put their reference number in so they can do a search of that client in the future. And they might want that reference number to go on every page, and they might also, the accountant might want their own logo to go in. While the accountant, financial advisor and lawyer are mere scribes, they're just putting data in, They're not building the will. We own the will. We own copyright on the will. We cover the PI insurance. We are a law firm, and therefore the document belongs to us, and we are the authors. So we're now at the summary page. This gives us a chance, because we want to make sure it's correct. You now quietly go through and check everything's spelling. Whoops, that's not. Brett has a middle name. I better put Brett's middle name in. So I'm just going to go back and fix that up. Middle name is let's make it Paul. Type in Paul and now go to the summary, and that will be picked up in the summary. It's important to put correct spelling of names, particularly for children. I'll never love you if you misspell their name. So there it is, Brett Paul Davies. It's picked that up. Executors are in, Mary, Angelina, the doting auntie. She won't need to do the job if my children or the client's children are over 18. Oh, look, there it is there. My name of the person's Brett Davies should be Brett Paul Davies, so I better change that as well. So what was that in? That was the residuary beneficiaries. So let's go to residuary beneficiaries and fix that clause up. Now we go back to the summary. I fixed up that. That was good pickup, good proofreading. And it's picked up Brett Paul Davies. Excellent. Everything else looks correct. The spelling. So I'm now going to press lock and build. As soon as I press lock and build, the document's locked. Obviously, we have a full money back guarantee in case there is a mistake or spelling error, or you want to change your mind. We have a full money back guarantee on all the documents we sell. Put my credit card details in and press next. And within a few seconds, the document is built. It's saved on my hard drive. Just saved it onto my hard drive. It also is on the website, so you can go back to log into our website 20 years later and retrieve the document. And it's also emailed to you, so you can email it to your client. And there it is, simple, single will for Mary Popular. We've done it, didn't take too long. That's Mary there, date of birth, yes. She's appointing 3 people. They had 2 children and a backup, young Angelina, just in case Mary is underage. The age majority was 18. We just left that as standard, which most people do. And she's giving everything equally to Brett as an amount of half, and her daughter Mary as of half. Clause 5 is interesting because if Brett dies before the client, then whatever Brett would have got will go to his children. And if he doesn't have children, it will just go to Mary. So it's a bloodline gifting to each child, then to the children's children, and if all the children are dead and the grandchildren are all dead, it flicks back to Mary. Minors and bankrupts are interesting because if the child is, say, 6 months old, then they haven't reached the age of majority, which has to be at the minimum at 18, then there's still money for maintenance, education, advancement, support, and benefit, which means not only toilet paper or food and shelter, but also perhaps a car to get to university with. So that allows the executors to use what money is necessary for that child's half in order to help them. And obviously when the child turns the age of majority, which is in this case 18, then that child uses the money as they see fit. There's executors' powers. There's a contemplation of marriage, which we put in case the client marries Fred Jones. If she doesn't marry Fred Jones, it doesn't matter. If she does, it doesn't matter. The will's always valid. She's got a guardianship clause, which is her oldest son to look after her daughter, which is quite common. Clause 10 protects the integrity of the document in case there's changes in the law. This protects, as far as it can, the gifting provisions to the 2 children and then to the children's children. Witnessing on every page in blue ink, and there's a signing for young Mary. And there's a covering letter. All our documents have a covering letter telling you what to do and how to sign the documents and other things you might want to consider. So there you have it. You have built yourself a simple single will. There are 3 other types of wills you could build, but this client has decided to build a simple single will. As you build it, You're welcome to telephone us. You can watch the training videos, you can read the hints. But you can always telephone us. We're a law firm and we can give legal advice. So enjoy the advantage of using a website which is completely controlled and owned by a law firm.